As you will each have 30 minutes, and I will try to help you with your time because I know you can't see a timer like you would in the courtroom, but if you could also please try to watch the time yourselves, that would be great. With that, we will hear first from the government. Mr. Flengy, please proceed.
May it please the court. I'm August Flengy with the Justice Department here on behalf of the United States. I'd like to reserve 5 minutes for rebuttal. The executive order at issue puts a temporary pause on entry for individuals from 7 countries that Congress and the last president determined, in a similar context, pose special risks in terms of terrorist infiltration into our country. Those determinations were made in 2015 and 2016, based either on a congressional determination or statutory factors, including their foreign terrorist organizations had significant presence in the country, or the country served as a safe haven for terrorists. The order also temporarily halted refugee program. This judgment was well within the president's power as delegated to him by Congress, and it is constitutional, as the court in Boston in Halal Kalam recently held. Under Section 212F, Congress has expressly authorized the president to suspend entry of classes of aliens when it is necessary or when otherwise it would be detrimental to the interests of the United States. That's what the president did here. And the president's determination that a 90-day pause was needed for the 7 countries at issue here in order to ensure adequate standards, and that's language from the order, for visa screening was plainly constitutional. The district's court's order, which contained no assessment of the legality of the order, was in error, and we encourage the court to stay. A key factor in the order and its temporary nature was the president's determination that there was a need to review existing practices for screening foreign nationals who apply for visas.
This is
the order
if I can interrupt for a moment. You're asking for a stay of the temporary order of the district court. No matter which way we rule on your stay, presumably that appeal of the order remains in place. Is that correct? Or are you trying? Sometimes I get the impression from the papers that we're trying to argue the merits of that appeal itself rather than the merits of the stay.
Yes, Your Honor. There is some overlap, but yes, we are at this point just asking for a stay pending review by this court. Of course, the standards are pretty similar since both would look at the traditional injunction standards. With respect to those standards, I do want to say there are 2 kind of significant irreparable injuries that we are citing in support of our request for a stay. The first irreparable injury has to do with the assessment of risk that the president made in balancing our interest in welcoming people into this country with our interest in making sure our procedures are secure so that the risk of terrorism is acceptable. The president struck that balance, and the district court's order has upset that balance. This is a traditional national security judgment that is assigned to the political branches and the president, and the court's order immediately altered that.
Have you offered any evidence to support this need that you're describing for the executive order, or are you really arguing that we can't even ask about whether there's evidence because this decision is not reviewable?
Sure. The order itself includes findings. Those findings recognize the crucial role that screening presents in the visa process. They recognize that numerous foreign-born individuals have been convicted or implicated in crimes since September 11th. It recognizes that deteriorating conditions in certain countries create further problems. So the order created a pause so that the screening process could immediately be reviewed to ensure it's adequate.
Has the government pointed to any evidence connecting these countries with terrorism?
These proceedings have been moving very fast. The strongest point on that is that in 2015 and 2016, both Congress and the administration made determinations that these 7 countries posed the greatest risk of terrorism. And in doing so, restricted visa waiver to people who had even traveled to those countries over the last 5 or 6 years. The executive order relies on that determination, and that is, I think, the strongest type of reliance, where the president is relying on Congress's determination that these are countries of concern, and Congress's procedures to identify countries of concern based on significant terrorist activity in the countries.
This is Judge Clifton. I understand the concept of that, but it's pretty abstract, and it's not like there haven't been processes in place to take some care with people coming from those countries. Indeed, those are the determinations in the statute and by the prior administration you're pointing to. Is there any reason for us to think that there's a real risk, or that circumstances have changed such that there would be a real risk if existing procedures weren't allowed to stay in place while the new administration conducts its review?
Well, the president determined that there was a real risk. That's why the president determined that the best course was a temporary, it's a short halt in entry for 90 days while these procedures are looked at. And that's understandable. The president comes into office with an obligation to protect the national security of our country. The president understands, and it explains in the order, that these visa screening procedures are crucial. And the president understands that Congress identified these 7 countries, as well as in 2016, the president.
This is Judge Canby. Of course, in naming those 7 countries, what Congress did was to provide that people coming from those countries had to get visas. In other words, they couldn't just come into the country without a visa. And that permitted, of course, the usual investigations before you give somebody a visa. And in the transcript of the hearing in the district court asks the representative of the Department of Justice, you're in the Department of Justice, how many federal offenses have we had being committed by people who came in with visas from these countries? And the ultimate was the answer was there haven't been any.
Yes, Your Honor. These proceedings have been moving quite fast, and we're doing the best we can. I can
You're
cite...
saying that the proceedings are moving fast, but you appealed to us before you continued in the district court to develop the record. So why should we be hearing this now if it sounds like you're trying to say you're going to present other evidence later?
Well, I was just about to at least mention a few examples. There have been a number of people from Somalia connected to Al-Shabaab who have been convicted in the United States.
Is that in the record? Can you point us to where in the record you're referring?
It is not in the record. There has also been other examples, but again, you're correct. These are not in the record. The reason we sought immediate relief and a stay is because of the district court's decision overrides the president's national security judgment about the level of risk, and we've been talking about the level of risk that is acceptable. As soon as we are having that discussion, it should be acknowledged that the president is the official that is charged with making those judgments. I'd also like to
So are we back
talk
to
briefly.
are you arguing then that the president's decision in that regard is unreviewable?
Yes, there are obviously constitutional limitations, but we're discussing the risk assessment.
What are the constitutional limitations that the government acknowledges?
I would more say that the plaintiff has asserted various constitutional limitations. And I think the case that is most on point as far as constitutional interests are Mandel and Din. And in those cases where you have a U.S. citizen raising a claim, the court looks only at the U.S. citizen's constitutional claim, and even then looks at whether the decision is facially legitimate and bona fide. The executive order here meets that standard easily. It relies on...
In both of those cases, though, specific statutes by Congress that set forth specific criteria that were then applied factually were at issue. The president is not applying any specific criteria from Congress here, is he?
Yes, the president is. The president is applying Section 212F, which authorizes the president to suspend entry of classes of aliens if their entry would be, quote, detrimental to the interests of the United States. It now, the Supreme Court recognized that Congress and the president share the act of exclusion of aliens is a fundamental act of sovereignty that the Congress and the president, they're within the powers of Congress and the president. So our point would be that there's limited review, and the executive order, at most limited review, and the executive order easily passes that test. And that would only be true if there's a...
What kind of limited review do you acknowledge is appropriate?
Again, we're not acknowledging any review on the facts of this case because of a lot of standing and other problems with the state bringing the claim. What we acknowledge is that Mandel conducted a limited review to see that the decision was bona fide and legitimate.
Haven't there been allegations here of bad faith? And doesn't Mandel and Din, the concurrence in Din, envision that that's something that we would need to look at?
When reviewing executive order of the president under Section 212F, the review should be confined to the four corners of the document to determine if the decision itself and the executive order's findings have any issues with respect to the standard. And again, I'm sort of far ahead of our position. This would be if there is a party in the U.S. with standing to raise their own constitutional claims, and there are problems at each step of that analysis. The state of Washington doesn't have these kind of constitutional interests. The state of Washington can't bring a parens patriae suit on behalf of its citizens in this context. And
let me interrupt you for a second there. There's some talk in the Supreme Court cases of quasi-sovereign interests. And, for instance, a state might have an interest in clean air. And when it sues to protect its air, it's necessarily acting for its citizens. A state itself can't smell air. It can't see air. It has to be acting on behalf of its citizens when it brings a case like that, yet there seems to be authority for the state to bring that kind of a claim.
Well, the problem in the immigration context, and actually more generally, is a third party can't challenge visa denials or revocations. The claims that the state is bringing are essential.
Sure they can. Look, I mean, the whole point of the Din case was that Din himself, or rather Din's husband, couldn't challenge, but she could. And 3 justices of the court were prepared to throw it out at the first step, but the other 6 justices were not. They took up the claim. Why isn't the state of Washington in a comparable position say, as the proprietor of the state universities, having the same kind of interest that the scholar plaintiffs did in Mandel?
Well, the problem is because the state's asserting a parens patriae theory, where
That's not the only
Well,
theory.
they're also asserting
They've
their
other
own interests
theories.
as proprietors of the university and otherwise. Tax revenues?
yes, but let me finish with the first theory, and then I'll get to that. The parens patriae theory assumes you're asserting the rights on behalf of the beneficiary, but there's well-established law that in the immigration context, the sort of third-party interest, and the case O'Bannon describes this, is not something that can be asserted. I'd also
I suggest
add
that Carey versus Dinn asserts exactly that. I mean, in Carey versus Dinn, the plaintiff, Dinn, was the wife of the person who was excluded. So the person who was excluded may not have had any rights that he could assert directly, but his wife was allowed to.
And the state doesn't have the sort of constitutional rights that the wife in Dinn had. The wife in Dinn was asserting her own.
No, why isn't the state's right the same as the scholars in Mandel? Mandel was a foreigner. He might not have had rights, but the court took the case up because the people who argued they wanted to be able to hear him, the various universities to which he'd been invited. Well, the University of Washington, Washington State invite people. Why doesn't the state of Washington have the same standing that the scholars did in Mandel?
Again, you have to look at sort of the right of the state, and I guess I was discussing the right of the state on behalf of the people that it's bringing suit on behalf of. It's sort of collapsing the inquiry.
I understand you're moving away, or I'm dragging you away from the parens patriae theory. Just speaking for myself, I agree with you on that. The state can't do that. But the state has also asserted a proprietary interest, in particular as the owner and operator of the universities. And it seems to me they line up very much as the way the plaintiffs in Mandel did.
Well, on that point, our claim is that it doesn't have a judicially cognizable or legally protected interest in third-party immigration benefits. The
But
statutory
that's exactly
scheme,
the same case that was raised in Carey versus Dinn. And the majority of the court didn't say that. That was an immigration case. Mandel was an immigration case, both involving visa denials. And yet the court took them up.
Sure. Then we have to talk about what the constitutional interest of the state entity is. And it's well established that there's no due process.
Let me stop you there. Why is it limited to the state entry? I mean, in Dinn, she wasn't asserting her own rights; she was asserting her husband's rights. In Mandel,
No, she was asserting her. Sorry, Your Honor.
It was her right as the wife, claiming the loss of consortium and so forth. But the visa denial was to her husband. In this case, the state of Washington is claiming that it's going to hurt the university if it's not able to have these people come to the university. That sounds very much like the same kind of right that was asserted in Mandel.
Well, hurting the university isn't enough now that we've turned on to the actual challenge. The state has to have a constitutional interest, because in Dinn it was the constitutional interest of the U.S. citizen spouse that the court was looking at. And if
so
you
what
get
was
behind
the constitutional interest in Pierce versus Society of Sisters, where the school was allowed to assert the rights of the students and their families?
That was a case where, if I remember correctly, the university was acting on behalf challenging a state law that affected its students. There you would have constitutional interests for the students at the school. Here, aliens would not. I do want to turn to a very important...
Isn't that the merits question? So why can't we reach the merits question through the third-party standing asserted by the universities and the states here, the universities are part of the states.
Well, I think it all gets tied up together a little bit because of the well-established authority that a state entity can't assert these kind of rights, and even on the merits, I would like to point out that the executive order relied on the congressional and administrative determination of years ago of 2015 and 2016. So it's not an order that discriminates in a way on the basis of religion, and there would not be a valid equal protection. I do want to, before I run out of time, go ahead.
No, that's all right. Could the president simply say in the order, we're not going to let any Muslims in?
That's not what the order does here.
Oh, I know
and
that.
The order relies on...
I know.
Sorry, Your Honor.
Could he do that?
That's not what the order does.
Would anybody be able to challenge that?
That's not what the order does here. I do really feel... I do want to get to one key point.
Well, we'd like to get to an answer to that question, because it speaks back to the standing issue. If the order said Muslims cannot be admitted, would anybody have standing to challenge that?
I think Mandel and Din give a route to make a constitutional challenge if there were such an order. It would be by a U.S. citizen with a connection to someone seeking entry. This is a far cry from that situation. I'm not sure I'm...
Is there a purpose in standing doctrine? I mean, standing is supposed to ensure adversity. Is there any purpose for your argument that we shouldn't recognize this lawsuit by the states and we should instead wait for an individual to bring the same claims? What's the purpose of that?
Well, there needs to be a concrete, legally protected interest that's judicially cognizable. And the people, I mean, across the country, there are many lawsuits where there clearly is standing. There are people impacted by this order, and there are cases across the country where we don't have these type of standing arguments. But in this case, there's a lot of law that says states can't step into the shoes of their citizens in this context. We have the sort of proprietary interests are very diffuse, and if we credit them, there would be almost no limitations on standing. I think in that context, it doesn't make sense to extend standing jurisprudence to cover this kind of situation. But I'm not sure I'm convincing the court, so I want to make one really key point with regard to the injunction, and that is that it is overbroad and should be immediately stayed to the extent it is overbroad, even if the court thinks some applications of the order are problematic. The state has admitted that people abroad without prior U.S. contacts do not have rights that can be asserted by them, and we agree. In the district court, the state said our claim is primarily focused on the people who are here or who have been here and left. And on appeal, the states went further, explaining, quote, "This case, by contrast to cases on entry, involves longtime residents who are here and have constitutional rights," end quote. That is the nature of the state's claim. The injunction goes far beyond that.
The states are claiming that the executive order violates the Establishment Clause. If that's true, and it can't meet the standards that the Establishment Clause would impose, then wouldn't it be invalid on its face?
Your Honor, the state has said that their case, quote, "involves longtime residents who are here and have constitutional rights," end quote. That is from their brief at page 10.
But if some of
If
those
that
rights
is the
are
scope of their,
Establishment
if
Clause
that is
rights,
the scope
then,
of,
if some of those rights are Establishment Clause rights, then can't an Establishment Clause claim be made by one individual and invalidate the whole thing? I'm not sure why that's responsive.
the scope of the injunction, whether it's nationwide or anything else, should be limited to the scope of what the state itself says it is kind of representing through its various theories of standing. Issuing a broader injunction violates the principle that an injunction should only be as extensive as is necessary to fully remedy the claims of the parties.
Don't any of the, this is Judge Canby, don't any of the declarations indicate that the state universities invite foreign scholars to come to the state, make presentations, come for a time, go back, and that they wanted to continue doing that, which means there probably would be future invitations to scholars who do not yet have a connection with this country.
I believe there are some declarations along those lines, but I am describing the actual statement of the extent of their suit that they made in the brief to this court. And to the extent that is the relief they seek, this court should immediately stay the relief that extends broader, and that is to people who have never been to the United States. And Section 5 of the order, which is the refugee provision and applies to people who haven't been here yet and don't have those relations with the university and don't quote involve longtime residents who are here and have constitutional rights. I'm into my rebuttal time, but I would strongly encourage the court, even if it has concerns with the government's position, that it immediately stay the portion of the injunction that applies outside the boundaries of the U.S. And extends beyond people who who are in the U.S. or who have been in the U.S. Thank you.
Thank you. Mr. Purcell?
Yes, Your Honor.